protection, but that's a good question. Yes?
I have a C Corp in Nevada.
Okay.
Is it necessary to transfer that to Delaware, or is it necessary?
Yeah, I mean, if you have a lot of traction and you're killing it, obviously investors are going to be really happy and excited, and so they'll work with you. What they'll often do is say, as part of the closing, you have to convert, or sometimes it's tricky. You have to merge a corporation to a new Delaware corporation. But what happens is, you don't really want to give an investor a reason to say no. You think about it. They got 100 people banging on their door. They're going to choose 2 or 3. To the extent you're in Delaware and you have all these documents taken care of, you're demonstrating a certain level of sophistication and credibility. Give me a reason not to say no. When you come in there and you say, "Hey, I'm an LLC in Nevada," it's like, you know what, clean this crap up and then come back to me. And that's what happens from time to time. Yes.
I've heard somewhere that you can be an LLC, but it has to be your tax classification.
Yeah, you can choose different things, but that really doesn't help because you're still an LLC, and so at the end of the day, you have to somehow become a corporation prior to the VCs investing. By the way, from time to time, again, if you're really killing it and things are happening, VCs will try to work with you. There's ways of setting up like a blocker corporation, all kinds of complicated thing that they'll say, "Hey, you can stay as an LLC," but generally speaking, you want to be a corporation. Yeah, I'm sorry. Go ahead.
I was going to say, so would that take care of that? Because you said it's an accounting nightmare to be an LLC, just from an accounting point of view. If you do what I just said, would that take
Maybe, yeah. It just depends. When you converting an LLC to a corporation is not easy, and often there are significant tax issues. We did something about 6 months ago, and I wasn't involved with. They had to bring in a tax firm in D.C. I think it was like 15 grand just to take that. Then he had a tax hit, so you don't want that. I mean, that just happened because someone, they didn't seek counsel early on. They just assumed, or they had an accountant tell them an LLC. And there's no reason. If you're not going to be seeking outside investment, if you're going to bootstrap, an LLC can be fine. There can be many advantages. LLC offers extraordinary flexibility for both management, for distributions. Really great for a private equity firm. It really requires more of a sophisticated group of people. Private equity firms will often use LLCs. Hedge funds, real estate, it's very common. It's just these operating agreements can often be 70 or 80 pages, 10 pages of which are just the tax stuff. And so it's very complicated. I've seen people just do these LLCs and pull a form off doc stock, but that's not what you want to do. So, I'm sorry. Do you have a question?
What did you call the new law that's for entrepreneur and investor?
It's Internal Revenue Code Section 1202. Is that what I said? Qualified small business stock. That's the term of art. Yeah, that's important. I'm sorry. Was there a question here? Yes. B?
Yeah.
As in Bumblebee? Or the letter B. B corporations. B. Is that like nonprofit type corporation? Yeah, I've heard of those. I think some states have started authorizing them, but I'm not that familiar with those. That's kind of a specialty. Yeah. You had a question? Oh, I'm sorry. This is like the auction. You rub your nose and it's like, all right. Yeah.
Slightly tangent. If you're early stages with a couple of partners, what is the minimal set of documentation or legal documents that you need to proportion who's going to get what, so there are no discrepancies later on?
Yeah, we're going to get to that. That's a great question. So just hold that one, because I think that's the third mistake, if I remember correctly. You had a question? Oh, I'm sorry. Is it? 1202. 1202. Yeah, the other code section you need to know to tell your accountant when you form a C Corp is 1244, which gives you up to $50,000 of deductions relative to your corporation, so it's almost like you're an S Corp. So a lot of accountants, this is what's hard about being in LA. I worked many years, I said, in New York. I have an office in San Francisco. I spent a lot of time up there, and unfortunately down here, it is a great community, but some of the service providers just are in a different world, And I've had a lot of problems getting accountants involved with my clients. They don't understand the startup world. They're in a different world, and so I have to be the guy. Tell them, well, do you know about 1202? No. Okay, great. Goodbye. 1244. So up in the valley and in San Francisco, everybody's on board, and that's why I love it up there because. All the accountants, the lawyer, everybody kind of gets it. And so you really have to be careful. It's a separate issue, but, you're putting together a team. You got to make sure all the people involved in your team are experienced, right? Experience in the startup world, completely different world than obviously when accountants are dealing with corporation, Fortune 500 corporations or 100. So that's important. Were there any other questions before we went? We just covered two mistakes. So the first being, as I said, IP ownership. The key point being the fact that you have to recognize your employer may have certain rights with respect to your venture if you're not careful. The second mistake is choosing the wrong entity. If you're seeking, as I said, any type of outside investment, you want to form a corporation in Delaware. Okay. The third mistake we're getting into is, I'm laughing because this is how it builds up, and people walk out. I hate lawyers, you know. These fucking guys are driving me crazy. A lawyer is like insurance, you know. You're trying to pay a guy, so if something goes wrong, you know, that's the way I look at it. You know, you got a guy who watches your back. Is it worth the money? You have to assess the risk. I mean, this is the whole game. Whether you're a smart private equity firm buying a corporation for billions of dollars, at the end of the day, you want to know all the risk and you want to assess them as a business person. If you just wing it and do it yourself and go on LegalZoom, obviously there's significant risk there, but maybe you don't care. You know, maybe it's like, look, I'll see what happens. I'll figure it out later. That's fine. But just make an informed decision. I don't think that's a prudent decision. Many successful entrepreneurs will say the same thing, but others will be out there saying, you got to be scrappy. You know, screw the lawyers. You can figure it out. Go on the phone. So, make that decision. Make an informed decision. Just don't say, I don't have the money. I can't get a service provider. Maybe you borrow the money. Maybe you work a little longer to put a little money aside. Third mistake relates to the whole. Now you have a co-founder. You're ready to go, and you formed your corporation, and now we have to split up the equity, right? And there's sort of two issues associated with that: sort of splitting it up, dividing up the pie, percentages, and then and we'll talk about that. And then there's the issue of vesting. Everybody familiar with the term vesting and understand that term? Because we'll get into that. They're kind of related. And so the mistake is what happens 9 times out of 10, 2 guys come to my office, and what are you doing with the equity? Split it 50-50. 3 guys walk in, we'll split a third, a third, a third. 4 guys come in, 25%, so that's the mistake. I mean, that's kind of, it sounds fair, right? We'll just split it, but that's not really, what should happen from a business perspective. This is a business issue, right? So one person could have been, busting his or her ass for the last year on the venture, and now brings in their friend, presumably. You always want, ideal co-founder. We'll talk about that, maybe next time. Good friend brings him or her in, and what is 50-50? Well, it doesn't make sense. 50-50. This person's been working full time for the last year, and you've been kind of, you came up with the idea. You've been hustling. You've been putting it together. You've been coding, whatever. So, maybe 80-20, 70-30. But I think that's the mistake. Okay. Very tough issue. I sit down with clients all the time. We try to figure it out. There are a number of factors involved. There's no right or wrong. You kind of have to sit down. Okay, who's put the most time in prior to incorporation? What's the expectation going forward? Maybe some person's going to work part-time. The other person, this is their full-time job. Who's the most valuable person? Who is the contacts? So this is just strictly a business issue. I raise it as a legal issue because, you can't just say a third, a third, a third, or half, or half. Then you have the legal issue, a half, 50-50. Well, you can see the problem, potential problem with that. Deadlock situation, 2 people on the board. How do you work that out? So all kinds of complications there. So I don't want to spend too much time on that, but I just want you to sort of have in your mind, because the reflex is, we're starting a venture 50-50. That should not necessarily be the case. Normally that's wrong, okay? So that's the mistake. But vesting, so here's the number one issue. Of all the issues that I'm going to talk about tonight and next time, it's not setting up vesting schedules. And for those of you who don't understand that, I mean, this is like the big enchilada. 2 people, and it happens all the time, I get calls all the time, 2 people start a venture, they don't use a lawyer, they use LegalZoom, they're playing lawyer, and 6 months later, a year later, that's when I get the call, hey Scott, I found you online, whatever, my co-partner, my founder, just left, and he's got 50% of the equity. What do I do? What do you do? I mean, what do you mean, what do you do? Do you have a vesting schedule? No, we didn't do it. We did it online. Well, you got a problem, man. I mean, what do you mean? What do you do? What should happen, and what we do, is we'd set up a vesting schedule. There's a document called the Restricted Stock Purchase Agreement. It's this, technical document, but what it does is it basically vests the shares over time. Over 4 years is pretty typical, and on a monthly basis. So if that person leaves after 6 months, he or she would get what is it? What's the math? 1/8 of the equity, and that's kind of fair, right? So if they had 50%, they get 1/8, and they're gone. And so, okay, they earned it. They shouldn't get 50%, right? And so this is really important. This is sort of the common mistake. There are also issues. So how much vests up front? Because maybe you want to have what's called a one-year cliff, a one-year cliff. What is that? Well, if you don't really know your co-founder very well, you maybe say, you know what, Charlie, we're going to vest, but I don't think you should vest immediately. You got to prove yourself. You got to be here for a year. Then you'll get that first quarter tranche. And then after that, it'll be monthly, okay? This way it protects you. The guy leaves in 6 months, he gets nothing. Leaves in 9 months, he gets nothing, right? That's what maybe it should be. Normally, good friends, again, that's the best arrangement for co-founders. You know each other, you trust each other, you're in for the long haul. Normally, you just start vesting. You may even pre-vest. You've spent 6 months on it, you haven't incorporated. But that's an important issue. And if you set up a reasonable schedule, like I've said, 4 years monthly, then when you talk to the VCs, because the VCs are going to set up a vesting schedule, whether you do with initially or not. That's the bottom line. And this issue, a lot of entrepreneurs don't understand that. You go to the VC, guess what? They're not putting money in your company unless you got a vesting schedule. They want you there. And so entrepreneurs are like, what are you talking about? I've been working on this project for a year, and you're telling me I don't own my shares? I have to give it back? That's right. That's exactly right. That is an absolute non-negotiable issue. There's no VC that's going to put money. I mean, look, maybe in a rare situation, Facebook, whatever, but the bottom line is you're going to have to set up. So if you say, hey, it's a year later, we already have a vesting schedule set up. Look, if that's though we each have, 1 year's worth, let's just keep it in place. Okay, that looks good. It looks reasonable. And again, sort of demonstrating credibility and sophistication. We've set this up. Okay, these guys are good. They get it. So that's mistake number 4. Any questions with respect to sort of equity and splitting the equity and vesting? Yeah.
Do you affect the vesting if either or both founders put in money?
Yeah, that's a great question. So that would be another factor to consider, right? Certainly in terms of the split, I'm not sure what the one puts in. It depends how much money we're talking about. I'm sorry. So the question was, what's if one founder's putting in money, presumably like a significant amount, does that affect the vesting? Certainly, the vesting up front, since they're putting in money, you would presume that why should that sort of vest now? It also would affect, I would assume, sort of how you're splitting the equity. Speaking of this issue, by the way, in terms of money, so a lot of people say to me, Scott, why the hell do I even have to incorporate? And that's kind of like part 2, choosing the entity. Why don't I just wait? Why don't I wait for 6 months? Why don't I wait for a year? See how things go, right? Then I'll decide to do this damn incorporation, get the lawyers involved, and below $3,000, whatever. And the answer is, one of the issues is in terms of valuation, the key is by incorporating early on when the company has no value, you're able to get the shares into your hand at a nominal price, like basically nothing, right? $50, $100. The longer you wait, presumably you're building value as you hit milestones, as you get customers. And so then the investor comes in, hey, I'll give you $200,000 for 20% of the company. So the company's valued at $1 million. You don't even have a company yet. So how do I get the shares into the founder's hands now? Because the founders now technically own $800,000 worth. And the answer is you got a problem. And so this comes up all the time from a tax perspective. I'm friends with a good tax lawyer up in Silicon Valley. So I'm always picking his brain. What's the IRS? IRS may audit something like that. The way to solve that is instead of the investors coming in for common stock, they either do preferred or convertible notes, and so we don't have to get into this valuation issue. I didn't mean to go off track here, but that's a question I get all the time. Scott, why do I even, And the second reason is because of personal liability. So if you get sued, you want to have an entity to protect you, right? You want to either be a corporation, if, of course, you're going to be seeking outside investors, or you can be an LLC if you're just going to bootstrap and you're trying to just basically, keep it simple and you want to have the flexibility of an LLC. Those two entities protect you from personal liability. What kind of liability? Personal liability, meaning if you have any assets, money, a house, a car, and you get sued, if you adhere to all the corporate formalities, you would not be able to be sued personally, okay? So only the entity would be sued. Who cares? It's just a shell, basically. It has no assets, so you file for bankruptcy, the shell's gone. If you sued personally, and for some of my older clients, they may have significant assets. So that's another reason you want to try to incorporate early on, right? Does everybody understand that? It's a really important concept. I'm sorry I didn't bring it up earlier. So, yeah.
Just to bring back kind of mistake number one with the IP. Let's say you
Yeah.
have